Good morning, all of you. On behalf of Atal Community Innovation Center, Kalasalingam Innovation Foundation, I welcome all the students, research scholars, and faculty from the various colleges of Virudunagar district and the prize winners of Ideathon 2025 for the today's IPR event. Atal Community Innovation Center, Kalasalingam Innovation Foundation is a Section 8 company worth 5 crores, which is equally funded by AIM, Atal Innovation Mission, Niti Aayog, and Kalasalingam Academy of Research and Education. In order to uplift the Virudunagar district, which is identified as an aspirational district, and it is lacking in terms of adapting new technologies. In our district, there is a small town named Sivagasi. It's a hub of firework matches and printing presses. Another town named Rajapalayam, which is famous for bandage cloths. Roughly 90% of our country need is fulfilled by our district. By generating few thousands of crores in revenue, and we are contributing significantly to the Tamil Nadu as well as India economy. Sivakasi is also called as Kutti Japan because of this reason, even though they are lacking in automation and modernization. The reason behind is most of the workers are not well educated and they are not from the well organized sectors. So upskilling all the laborers, all the workers is a very big challenge. We from ACIC KIF, we are conducting outreach events and capacity building events, and we are trying to identify and trying to giving solution from the educational institutes and startups by conducting ideathons, hackathons, and we are trying to bridging the gap, and we are trying to give the latest technology to the district via our team. In addition, we are helping them to protect their ideas. The startups who are all coming up with new ideas, we are recommending them to patent their ideas as well as patent and copyright their ideas. For that purpose, we are conducting IPR awareness programs. Today, Mr. Ramesh Kannan and Mr. Venkatesh from Mrs. Quadringa Private Ltd join with us to explain and assist our startups to getting patented and patent and copyrights for their ideas.
So what do you plan to do next? Build a MVP. Okay. And then?
Then we will try to monitor the pilot programs and we will try to get feedback for them.
Okay. Then?
Then we will try to sell them with some new
Okay.
pricing and stuff. And then
Why? Why do we do that?
and brand name is more than the person
Brand value is more than a person's value. Right? So, now all of you are in that crucial junction. You have an idea. Right? Your idea is your most valuable asset right now. It's an asset that you can't let go of. And that asset is what you hope will get converted into riches in the future. It will give you money. It will give you fame. Right? So, at this stage, it's an idea. In the future stage, you are hoping it will become a product. Once it becomes a product, you launch a startup. Right? And once you launch a startup, can you directly start selling your product? No, why? What is required there? Yeah, if the product requires regulatory approvals, fine. You need to get approvals from the government. But not all products will require regulatory approvals. But I am talking about something that is common to all types of products. Right? What will happen if someone else copies your product? What will happen? Huh? Huh? They will become competitors. And what happens if that competitor is a very big company? Can you fight against them? Huh? You lost your idea. Right. So at that stage, what should you do? Bare minimum, what can you do? What is the minimum amount of protection that you can give to your idea? Got it. Yes. Yeah. Yeah. So patent rights. They are the minimum amount of protection that you can give to your company. Not just patents. He referred to brand names, right? So for brand names, there are other types of IP. Do you know what that is? Have you seen TM? Yes, exactly. So patents, trademarks, designs, and copyrights. Right? These are the four fundamental forms of intellectual property. Your idea. Where did your idea come from? Your idea came from your intellect, your mind. Right? And your idea is a property right now because it is your biggest asset. It is not necessarily the same as other types of property. For example, this hall is also a property, but you can see it. No one can see your idea. So it's a different kind of property. It's an intangible property. It is not a tangible property. Okay? And a right, patent rights you said. So the right that is provided by the government to protect any property that comes out of your intellect is called intellectual property rights. It's a very, very, very simple, self-explanatory term. Right? You don't need anyone else to explain it to you. And right, if you want, if you have questions, in case you are unable to wait till the end. So, IPR refers to any types of right that is accorded to creations arising out of the human mind. So, your idea is a creation and it came out of your own mind. So, for that particular type of idea that came out of your mind, the least amount of protection that you can give is IPR protection, which basically predominantly falls under these four categories. Although there are other types of categories as well, but they are very rarely used. They are applicable only to selective, groups. These four categories are generally applicable, across the board. Any of you here have prior exposure with patents? But all of you have heard of the term patents. So what does it refer to? Patents are given for what? Tangible. Okay. Any other answers? Why are all the answers coming from there only? What about the rest? So patents are one type of intellectual property right that are provided for any sort of innovation or invention that has a technical character. Okay. By technical character, I mean that any invention or innovation that solves a technical problem. So all of you, when you started out with your idea, you would have come up with that idea only because there is some existing gap in the literature in that particular field. Right? So that is the technical problem. All of you would have set out to solve a technical problem, one or more technical problems in your field. you would have identified gaps in your field. Now, if to solve that gap, if you have invented a product or a process that is eligible for patent protection. What is the difference between invention and innovation? Huh? Invention is for a new idea, and innovation? One of you. Invention has more value compared to innovation, you're saying. Why? Oh, innovation has more value than invention. Okay. Any other answers? New ideas plus action is innovation. Okay. Innovation is adding values. Okay. Good. So innovation, you already have something to build upon, right? You already have a base product. For example, let's say, you're working in the mobile phone industry. You could pick up iPhone as your base product. And, you could add, value added features to the iPhone. That is called as innovation, right? But the very first mobile phone that came into the industry, that's an invention. It is a revolutionary or a breakthrough product that came into the industry for the very, very first time. So that is an invention. 95% of all patent applications are filed only for innovations. Keep this in mind. A lot of you have this doubt. What I'm doing is very, very small. It is not patentable. You yourselves decide it is not patentable, right? Then what is the need for, experts or, practitioners? We always have this doubt, right? Patents is for companies like, TVS, Bajaj, Infosys, Apple, Nike. I have nothing to do with patents. Patents are not at all applicable to me. See, irrespective of whether patents are applicable to you or not, if you want to form a startup, it is imperative that you apply for a patent application. Now that's secondary. But also keep that in mind, because if you approach venture capitalists or angel investors, your madam was telling me that, she is in talks with angel investors, right? So if an angel investor comes to you or, comes to ACIC campus here in Kalasalingam and, they talk to all of you as startups, they are willing to fund, some of you or all of you. What is the protection that they have? They are funding your idea. But is your idea itself protected? What if someone else steals your idea? What if someone else reverse engineers your product? Then where is the protection? The first thing that the angel investor will ask you is, have you protected this through IP protection? Have you filed a patent application for this? Nowadays, post COVID-19, they are not at all willing to entertain you if you have not filed patent applications. That is the first criteria to even talk to them. Right? If you want to pitch to them, first file a patent application and then go and pitch to them. Without a patent application, they will not even entertain you. Because that way, their opinion is that you are not serious about your idea. If you are serious about your idea, you will take all steps necessary to ensure that, it is protected. Right? So, it is definitely applicable to everyone, who is building products or, who is innovating in processes. Another thing that we generally think is patent to product. Patents can be filed for processes as well. Right? That's important in certain sectors like manufacturing, where, there are technical problems in processes. The process could be lengthy, the process could be expensive, the process could be time consuming. These are all problems. And you can solve these gaps. You can innovate. You can come out with processes, new processes. Right? But it is a win-win situation. It is a barter system. Right? The government gives you a right. You have to give the government something. What do you give the government? You give the government a complete disclosure of what you have invented. Why should I completely disclose my invention when someone else can easily copy it after reading what I have done? That is how the system works. That is why you are given a monopoly right. Right? Patents are not just for, protecting your inventions. They are a means of promoting research and development. Just like how scientific publications exist, scientific journals exist to promote research and development, patent literature is also a unique means of promoting research and development. How? Because you are giving a complete disclosure of whatever you have done. Once it falls into the public domain, others can read what you have done and they can innovate. They can build upon what you have done. If someone else completely copies what you have done, there are other legal mechanisms available. But you have to choose. Do you want to file a complete disclosure in exchange for a monopoly right? Or do you want to keep it as a trade secret? But don't go somewhere in between. You will get caught. You won't be here, you won't be here. But you can keep it as a trade secret only if you are confident that others cannot reverse engineer your product after purchasing it from the market. If others can easily reverse engineer what you have done, you might as well give a complete disclosure and get a patent for it. If you give an incomplete disclosure, you will not be awarded a patent because that is one of the most stringent criteria in Indian patent law. Don't get misled by reading US patents or European patents or other patents. Right? A patent is a territorial asset. So, US patent law and Indian patent law have no relationship whatsoever. Right? So, just because, something has been granted a patent in the US with incomplete information, doesn't mean that the same will be granted in India. The law is completely different. Our law is technically on paper one of the most stringent and one of the best laws in the world. Okay? Like I said, it is awarded for anything that has a technical character. Now, why should I patent? Right? Is it even worth all the time, effort and money that I am putting in? Why should I patent? There are lots of factors that go into deciding whether you want to file a patent application or not. The most important one is one thing I've already said earlier. If you want to approach investors, if you want to raise funding, you definitely need to patent your asset. Your asset is your product or your process that originated from your idea. Okay? So, raising of funds is one criteria. Now, if you want to generate revenue, right? Fine. I have, built my prototype. I have built my product. I have IP protection for it. I'm not able to commercialize it. What do I do? If you don't have the means to commercialize your product yourself, you can enter into agreements with third parties. There are two types of agreements that you can enter into. One is called assignment, one is called licensing. Okay? If you own a house, right? What are the two means by which you can earn revenue from that house? Selling or renting, right? Same. Licensing refers to renting. You retain ownership over the patent. You are just giving permission to a third party to exploit that patent. right? To commercialize that product. So licensing can be of different types. That is not needed for you right now. Assignment is the other type, selling. I have done my bit. I'm interested only in R&D. I have built a product. I have shown it works. I have patent protection for it. Let someone else commercialize it. I will sell it off. Same. Selling, renting, right? Assignment, licensing. Even there, a third party, will be interested in a license or will be interested in buying your technology only if you have patent protection for it. Else they might as well reverse engineer it and copy it and sell it. Inventor gets recognition among peers. This is more suitable for faculty in the academic domain because academic credit is very important for them. So, they generally think that, only publishing in scientific journals gives them credit, but being listed as an inventor on a patent application also gives them equal amount of credit. Is my invention patentable? What can be patented? I've already alluded to that earlier. A product or a process that has a technical character. What are the three criteria that should be satisfied? The product or the process should be novel. The product or the process should have an inventive step. And the product or the process should have industrial applicability. And apart from that, the product or the process should not fall under Section 3 and Section 4 of the Patents Act. If we have time later on, I will show you the slides about Section 3 and Section 4, which deal with what inventions are explicitly non-patentable under Indian patent law. So even if those inventions are novel, have an inventive step, have industrial applicability, if they fall under Section 3 and Section 4, they cannot be patented as per Indian patent law. So when we, think about patented inventions, we think about something, that is like, extremely complex, extremely revolutionary, something that is, anything but simple. That's not the case. Right from simple inventions all the way to simple innovations, all the way to complex inventions, all of them can be patented, right? Right now, there is a lot of research going on in shopping carts, believe it or not. And there are several ideas being generated from shopping carts, autonomous shopping carts, shopping carts with sensors in them, shopping carts with QR codes and in billing abilities, shopping carts that will generate the bill amount that you need to pay there itself, so that if you don't want, you can take out anything that you want, anything that you don't want. So there's a lot of ideation going on in the shopping cart stage itself, right? So likewise, all known products are nowadays being fitted with automation capabilities, sensors, right? IoT is the name of the game nowadays. Everything is being converted into an Internet of Things driven system. So it's all being connected with smart homes and automation, right? So, TVS actually patented its, central stand for its TVS Jupiter. What is that last one on the right hand side? Huh? DRS, yeah, Hawkeye system. So that was originally patented, right? A system and method for determining the trajectory of a ball. And Bajaj Pulsar. Pulsar was actually struggling in the market. It's a very good case study for Indian companies. Pulsar was struggling in the market. It was losing a lot of market share to TVS and Hero Motor Corporation when it actually launched the Pulsar. And it had patented the DTSI technology. That instantly gave it a push in the market, and it regained its lost market. So all of us know, right? We have seen with our own eyes how cars like Toyota Qualis gave Toyota a great push in the Indian market. At that time, it was actually very difficult for foreign companies to establish their presence when Toyota launched the Qualis. At that time, there was nothing to beat the Tata Sumo. Tata Sumo was like the be-all of the SUVs. And Qualis came in and it literally pushed everything aside. So all it takes is one product with the adequate protection and the right marketing strategy. Of course, as startups, you may not have the finances for marketing initially, but at least you can give it protection, right? And as and when it gains goodwill, you can start marketing it. So Qualis is one very good example. Bajaj is one very good example. And likewise, Tata Indica, right? When it came out. That was its first hit, I think, after Sumo. It showed that, it can also manufacture hatchbacks, not just sedans or SUVs. So, there are examples. Look around. A lot of the products that you see, right, they will have some interesting backstories to them. Every product will have some sort of backstory associated with it. Even your idea will have some backstory associated with it, right? All of you may have a family business. You would have felt a problem in that business, anything. How did that spark come from that idea? It should have come from somewhere. That in itself is a story, right? So, all it needs is, one genuine, valuable product. Initially, I'm talking about. In the current market scenario, you cannot sustain a business enterprise with just one product because nothing less. Novel means new. புதுசா இருக்கணும் தமிழ்ல சொல்லணும்னா அவ்வளவுதான், right? If there is a fan with 3 blades that's operating, if you have come up with a fan with 4 blades, that's new. That's it, right? This is fairly easy to satisfy. You take an existing product, product, you add one more feature to it, it's novel, right? But with respect to what should it be novel? It should be novel with respect to prior publication. And that publication could be patent literature or non-patent literature such as journal literature. Or it could be, product literature also on the internet, right? It should be new with respect to prior use. And it should be new with respect to prior knowledge. All of this not just confined to the territory of India, but elsewhere in the world also. India, like a lot of other jurisdictions across the world, follows the system of global novelty, right? When you file a patent application, the patent office will conduct a search, will examine your patent application by entering the relevant keywords in its own in-house databases. And that search will not just be restricted to Indian patent applications or Indian use or Indian knowledge. It will be a worldwide search. So if someone has done whatever you have done in Korea and they have protected through a patent application, and if the patent office finds out that this patent already exists, you will not be granted the patent. That is why your preliminary research is extremely important. When you identify the problem statement, make sure that that problem is a genuine problem that already exists, right? So, there are some free tools available for you like Google Patents. If you go to patents.google.com, just like how you do a search on the internet, you can enter relevant keywords and you can search across some important jurisdictions like US, Europe, Korea, Japan, China. This will give you an idea of, because Chinese are actually, frankly speaking, way ahead of us, in terms of literature and in terms of, commercialization. So whatever you have done, even if it is not in the market in China, may have been published in China. So, try to do a preliminary search on Google Patents and try to fish out what, prior literature exists in the same area as, the area in which you have ideated, just to be doubly sure that, there is a genuine space that is available there for you to solve a problem, right? Initially, you may think that, I'm going to commercialize only in India, I won't have a problem. That's fine. But what if your business scales up suddenly and you realize that you have an urgent demand to export overseas? There will be a very big problem there. If, patents exist in US or China or in other countries where you want to export. So you might as well be safe initially, right? Just a very, very simple example, right? This is actually a real-time example that was decided before the Intellectual Property Appellate Board. IPAB is nothing but a tribunal that decides IP cases in India. It is below the High Court. It used to exist in the past. Nowadays, it doesn't exist. So this was a fight that happened between two giants. It was a fight that happened between Tata Chemicals and HUL. Between the date of publication and the date of grant, your patent application can be opposed by anyone using pre-grant opposition procedures. So if someone feels whatever you have done is, similar to what they have done, they can oppose. After that, India follows a deferred system of examination. Deferred means you have to specifically request the patent office to take up your application for examination. It is not automatic. All of us, when we studied in college, when we studied in school, it was a fixed timeline that we followed. Exams will automatically come up. We need to write those exams. It's not like that. Here, we need to tell the patent office, I have filed such and such a patent application. This is the application number. I want you to take this up for examination. There is a timeline available, 2.5 years from the date of first filing. Within that timeline, you have to file an examination patent examiner to whom your application has been referred. An examination report will be issued. That examination report predominantly will contain a list of citations, prior literature, right, which destroy the novelty, inventive step of your invention. There could be other objections, formal objections, substantive objections. You have to rebut these objections within 6 months from the date of issuance of the first examination report. After that, it will go through another round of examination. If your response is satisfactory, it will proceed to grant. If your response is not satisfactory, you will be offered a second chance in the form of a hearing. First chance is response to examination report. Second chance is hearing. And even after hearing, if your responses are not satisfactory, a final refusal order will be issued. Or if after hearing your responses are satisfactory, it will proceed to grant, an acceptance order will be issued. After grant, there is a 1-year period where your patent can be opposed based on post-grant opposition procedures. This is just something you need to know, that's it. It is not something you need to go into depth, but just keep it at the back of your mind that your patent can be opposed at any stage. Post-grant opposition also, there is another window, right? So you always have to be safe at the time of filing your patent application. Provide as much information as possible. Make sure that there are no gaps in the draft that you file. If there are gaps, even if the patent office has granted you a patent, others can identify these gaps and they can ensure that your patent gets revoked by using the opposition procedures that are available in law. So minimum time period is, let's say you file a complete application, you file your complete document along with the patent application, you request for a fast tracking of the publication, and you file for the examination upfront at the time of filing itself. Bare minimum, it can take you 3 to 3.5 years for a patent to be granted. This is a standard time. Anywhere you go, even in the US, it will take you 2.5 to 3 years. Less than 3 years, it's very difficult to get a patent granted anywhere in the world, except for utility patents. Utility patent, by the way, in the US is different from utility patents in other countries. In the US, the utility patent is similar to our patent system, the normal technical patent. There is another type of patent called petty patents, right? Where, no examination is conducted and, there is a straightforward grant after formal examination. That is not available in India. It is available in some European countries, in China. So there, you can get a patent granted in maybe, 3 to 9 months, depending on the country. But there the problem is, there is no guarantee as to the validity of your patent, and anything has to be settled only in the court of law. I've already mentioned this. There is nothing known as an international patent. All patent rights are territorial in nature. You file a patent application in India, that patent rights are restricted only to the geographical territory of India. Likewise, if you want to file in the US, you file in the US. There are some mechanisms available, which if you want, we can discuss later on. Now, moving on to the second type of IP. You have filed a patent application. You have incorporated your company and you want to sell your product. So your product will have what will it have? What name will it have? Will you be selling it in your name? No. In what name? Brand name. That brand name is eligible for trademark registration. And like was beautifully mentioned by you all, a brand value is greater than a person's value. That is why we opt for brand names. Or else, we might as well sell it under our name. But, we live only for a definitive period. But brands live on forever. We know brands, right, that are 150 years old, 200 years old, 250 years old. They continue to stay in our minds. Why? It's because of their value. So, trademarks serve two important purposes. One is identification. Identification means they help a customer identify a product as originating from you only. Right? If you go out, if students of this particular university go out and say that they are an alumnus of Kalasalingam University, everyone will know what Kalasalingam University is. There is no conflict there. There is only one Kalasalingam University. Right? So, it is an identification of the product or the service with the origin of the product or the service. Second is differentiation. It differentiates your product or service from your competitor's product or service. That is where the brand name fits in. This is why it is not advisable to keep common names as brand names. Why? Can common names help you differentiate your product or service from a competitor's product or service? No, right? Generally, the first names that come to our mind are, common names when we think about brand names. But common names will not help you differentiate, right? If more competitors emerge with similar names, your name will get drowned in the crowd. It becomes extremely difficult to establish or to differentiate, right? So try to think of names that are fanciful. Try to think of names, that are not common, that can instantly establish a relationship between you and your consumers, and that will be hard to copy. Or if they are copied, you can easily sue them. You can easily take legal action against them. In case of common names, it becomes extremely difficult to take legal action because common names are names that are available in the public domain. Anyone can use them. Even if you have a trademark registration, it becomes extremely difficult to take legal action. Whereas on the other hand, if you have a name like Google, right? If you have a name like Infosys, if you have a name like Rapido, Zepto, whatever it is, right? These are all names that they themselves built for their own brands. You type in Zepto, dictionary will not show you any meaning for Zepto. Zepto is associated only with the delivery brand. Swiggy is associated only with the delivery brand. So, these types of names, although initially it will take some amount of effort to establish that name in the minds of your consumer, once that name gets established in your consumer's mind, it cannot be dislodged easily. So, think about some name that is fanciful. Trademarks are classification based. There are 45 classes, 34 classes for products, 11 classes for services. So let's say you are in the electric vehicle sector. Initially, you will be building a product, a bike, or three-wheeler, four-wheeler, whatever it is. So you will have one class in the product sector. But subsequently, there could be two classes. One is the sales of electric vehicles, and second is servicing of electric vehicles. Initially, you may not sell it yourself directly, but later on, you may sell it yourself directly. So these two are related to your product class. If initially you file only in the product class, someone else can take it up in these two service classes. So identify all the important classes and see if you need protection in all of them. That is why trademarks are classification based. A name, if it is registered in one class, doesn't mean that you can protect the name against competitors in all classes. You can protect it against competitors only in that particular class. Unless, of course, you are a very well-known trademark, which is not applicable to you at this stage. Trademarks have no meaning unless they are used commercially. Very, very, very important. Don't file your trademark application and then sit back until registration. Trademark registration may take 1.5 years, 2 years. If you are going to say, I want my trademark to be registered before I even start using it, there's no meaning. Trademarks are always associated with use. So, once you file a trademark application, start commercializing your trademark. The more goodwill that you are able to show, the greater are the chances of your trademark going through at a later stage. At this stage, you can forget about the other types of trademarks. This is just for your information. Generally, initially, the two types of trademarks that will be applicable to you are words and logos. Word means your brand name, your company name, or anything, a slogan. It could be anything, any combination of words that you have come up with that is associated with your particular company. Logo. Logo could be just the logo on its own or logo with your brand name, and it could have a tagline also, right? So these are the initially two types of applications that will be applicable to you, or slogans and taglines may also be applicable to you. Later on, you can, if at all they are applicable, you can think about color, sound, shape, and smell. Next slide. Yeah, I've already talked about this. The two important things that are applicable to trademarks are distinctiveness and non-descriptiveness. Distinctiveness means your consumer should identify your name, your product only with your brand. It should be distinct. It should stand out from the crowd. Right? It should not be a crowded space with a lot of similar names. Non-descriptive. If you are in the electric vehicle space and if you are going to, name your startup or name your brand as electric automobiles. That directly describes what you're doing. Such types of words are not applicable for trademark registration. It should not directly describe what you're doing. It could suggest at best what you're doing, but it should not directly describe what you're doing. Now, like patents, here again there are 4 stages. You file a trademark application. Then examination. Here, examination report will not come in all cases. There could be a straightforward acceptance also. But if an examination report is issued, you respond to the examination report. And finally, if a hearing is called for, you attend the hearing. Patents are valid for 20 years from the date of filing. But trademarks, right, they have an indefinite lifetime, provided you keep renewing them for every 10 years. And you can file trademark applications on a prior use basis. If you have already started using the trademark, you can say that I have started using it from such and such a date. And you can claim that prior date. Or you can say that I intend to use my trademark in the future, which means proposed to be used. And the minimum mandatory fee will be rupees 4,500 per trademark per class. The third type of IP is referred to as designs. Do we generally use the word design with a process? In this particular hall that you can see, these lights, this fan, the chair that you're sitting on, this particular desk, this water bottle, this mic, your mobile phone. Each of that is a unique design. So design registration protects the visual appearance of the product. So any product that you have come up with, if it has a new and original design, that you want to protect its visual appearance. In some cases, it becomes extremely important, right? Kinley water bottle, for example. That unique shape cannot be replicated by anyone because it is associated only with Kinley. So there are cases where, design is extremely important, especially in the automobile industry, in the electronics industry for, products like mobile phones. So there, design registration becomes extremely equally important when compared to patent registration. So it protects the visual appearance of how your product looks externally to a consumer. It is judged solely by the consumer's eye. You place 2 designs side by side. Is your particular design different from another design when a consumer looks at it? Designs are valid for 10 years from the date of filing. They can be extended by 5 more years. Same pathway as trademarks. Examination report is optional. There could be a straightforward acceptance as well. Filing, examination, responding to examination report, and hearing if any called for. So the minimum mandatory fee that you need to pay is rupees 1,000 per design per class. Like trademarks, here again it's a classification based system. While there are 45 classes for trademarks, there are 31 classes for designs along with the miscellaneous class. So now, once you have come up with a product, don't think that that product will have only one type of IP associated with it. Intellectual property, there's a reason why we call it intellectual property rights. We don't call it intellectual property right. There is a reason why it is always referred to in the plural. It's a bundle of rights. So one particular product could have multiple IPs inside it. If you have come up with, a particular type of electric vehicle, let's say for instance, any new technology inside that electric vehicle, you will protect it through patents. The brand name of that electric vehicle, you will protect it through trademarks. The design of that electric vehicle, how it looks, you will protect it through design registration, and all the software that operates inside that particular electric vehicle, you will protect it through copyrights. I haven't discussed copyrights yet. It will come in the final slide. So IPRs are always a bundle of rights. Don't always, stick to the fact that one product is equal to one IP. Identification of your IP becomes extremely important. You might have done a brilliant job in coming up with a wonderful product. You would have got feedback from everyone. Everyone says it's brilliant and all of that. But if you don't identify your IP and protect your IP at the right stage, then there is no purpose to building that product, because the current marketplace is extremely anti-competitive. There are copycats waiting everywhere. Their only job is to see which products are going to become hits and to copy those products and to sell them off in the market as their own product. So identification of IP is equally important as compared to protecting IP. So identification of IP is where a lot of people lack. They don't even know that they have IP in what they are doing, let alone protect that. How many of you have recently seen this news? All of you may have seen it. Ilayaraja versus the producers of Ajit Kumar's Good, Bad and Ugly. So why is this important? Why is Ilayaraja saying that, no one can, use songs without his permission? Is he right or is he wrong? Right. Why is he right? It is his composition. He is the owner of the composition, right? That is where copyright registrations come in. Copyrights are a type of IP that is applicable to literary works, musical works, dramatic works, artistic works, and computer software, cinematographic works. Now, don't get confused, because I earlier said that software is also patentable. The software, the technicality of the software can be patented, but the code as such can be copyrighted. So that is why software is unique. It falls under patents, part of it falls under patents, part of it falls under copyrights. So Ilayaraja said that, they are misusing his copyrights. Basically, when he filed the suit, he's saying that, he is the owner of these compositions. He has the copyright over these compositions, and without his permission, they have replicated. And now this is extending to the Dude film as well, right? Dude film, the producers of Dude film are also being sued by Ilayaraja. So it is a new trend that is evolving in Indian cinema, where earlier we used to have cases of plagiarism, right? Plagiarism means copying, taking off another story. Now, along with that, we are also having misuse of musical compositions. Until now, we had no issues. Ilayaraja's music is, songs used to be played in many movies. Until now, he didn't take action, but now he wants to take action, and he is entitled to take action because he is the owner of these compositions. So that is where copyright registrations come in. Now you tell me whether this particular line is right or wrong. Can I patent my copyrighted trademark? I've told you what patent is, I've told you what trademark is, I've told you what design is, I've told you what copyright is. Right? Can I patent my copyrighted trademark? What is eligible for copyright registration? I just now said it, right? Literary works, musical works, dramatic works, artistic works. So, is the term copyrighted trademark right? No. Yes, in certain cases you can trademark copyrights also, but it's generally no. Now, move on to the next part. Can a copyrighted trademark be patented? Do patents and trademarks serve the same function? This is the problem with this particular field, right? It how much ever we explain, all of it will be hazy inside your head. Yeah? So, did you get it out of the session? Is there anything else that you want? Set up, sir.
We are currently at the registered staff.
Mic கொடுக்கலாம் அவரு. Mic கொடுங்க.
We have very learning software. Can we reserve that? Okay.
Software. What is the purpose you are solving through the software?
We are actually helping the companies to hire for the project-based work. In that usually we have built agents and we have one platform where if a project gets was deployed. So from them they can go to their our agents are going to the agents. They are able to validate.
So for specific skill sets, you're looking for, they can easily, filter out candidates with those specific skill sets, right?
It is going for resume, it is going for project report. And if you comparing the, we are having hundreds and thousands of.
Okay. So, right? So, if you are able to filter out candidates in a better way, in a more efficient way, in less time, when compared to what others are doing, then you can definitely go in for patent protection. So, basically it depends on what is the problem you're solving. So, if there will be similar solutions, like you said, ATS already exists, right? And, if the only thing you have done is translate that to, project specific domains, then it may be difficult. But if you are able to distinguish your software from ATS in other ways technically also, and if there are advantages that you can portray, then, it may be eligible for patents as well as copyrights.
Number of projects, number of products, one is this another is handling the people for the company. Second part, after they will use our their internally, and they are going to get internally. Our internship LMS and third product which we have the project is learning in colleges, not that we are different LMS. So it's like pipeline we are giving from colleges to the hiring to the training, all we have done.
Yeah, each of these on a case by case basis we can discuss, and depending on the technicality that is being portrayed and the the outcomes that are advantages that you are able to get out of your product, we can decide which type of IP will be applicable.
Actually, we have developed a medical device, which is the real-time non-invasive glucose. Actually, we have the traditional.
I'm not able to hear you.
We have developed a real-time non-invasive glucose monitor. Actually, existing system is a normal hand-printing system. We are printing with a big hand, and connecting to the glucometer will show the glucose level. So without that, we are using NIR sensor. Actually, our patent was filed in the portal, intellectual property portal. Is there any process to easily getting the patent certificate?
When did you file it?
March 13th.
Of this year.
June.
Of this year.
Yes, sir.
It will take time. It depends on, what documents you have filed upfront. So, if you have not requested for publication and examination, you need to request for it right away. If you delay that, then things will get delayed further. And depending on who are all on board, you may be eligible for fast tracking of examination. But even that, there is no guarantee. But you can try. If if you want, if you give us the details, we can discuss.
You have submitted what are the patents already having on the existing.
I didn't get you.
You have submitted the details of existing patents on the same one, but it's not non-invasive, it is minimally invasive.
That is fine. But if you filed only in June of this year, it depends whether you have only filed it, whether you have requested for examination. It needs to go into the examination queue. It will take at least 2.5 years for everything to get processed. It depends, we will need your application number to, check what you have done. You have the filing receipt. You have the filing receipt, right? If you share the...
How much fee you have paid?
Not yet paid the fees.
How much fee you have paid?
Not yet paid the fee.
Okay, that fee might have been mentioned in that receipt.
No, sir. It's only they say publicly that
No, actually, no, even the receipt
Okay, no problem. You have the filing receipt, right? You share it with us.
Filing receipt, you have the application number. You can check online and we can let you know what should be done. That can be done.
So as I was talking about project is hiring. So we are at a rate of 5 and is it like consulting firms are already there with the hiring for the company. So we were having a conversation with them. Is it licensing you told about the company? And when we produce licensing products, we don't have that. I don't have that knowledge of it. Can you tell about it? How I can license?
See, here licensing works when you have a patent application and when someone else in a similar field, like you said, consulting firms, if they want to, let's say, if they want to use your technology but in your case, it's a software, right? So basically, you will be selling your software. You will be selling it either as a product or, or as a SaaS model. So in that particular case, in the software domains, licensing and assignment are very rare. Assignment maybe yes, but licenses are very rare. But in other domains, let's say, for instance, the domains that take a lot of investment, in terms of plant, machinery and all of that, if the inventor himself or if the applicant, in this particular case, he was saying that, they have come up with a non-invasive glucometer, right? So, they may not have the commercial capabilities to manufacture and sell that in large quantities. So, in that particular case, what they will do is they will identify companies in that particular area. And if those companies are interested in, selling that particular product, they can take up a license. And once they take up a license, you will still retain ownership. There will be a license agreement that is signed, which says, he is the owner of that technology. This particular third party is interested in selling that technology. And, they will become the authorized sellers. Often you will see, right, authorized reseller, authorized seller, that is licensed. Authorized franchisee. You would have seen all these boards, right? That is nothing but licenses.
Now, how you are planning to provide your software? Is it a standalone or a web-based or a SaaS management? What type of product platform is it?
As we started, first we start working for the people, initial customers. So we started we went to the IPR,
Even for that, you should have a model.
Yeah, we have the one.
What type of model you should have? How you are planning to provide
So, we are one part of the web page. Web page where status will be shown, where the comparison will be done, where the pipeline will be maintained. And another part is machine learning, where the agents are actually being
that is fine. What I am asking is how you are going to provide access to the end user. Are you going to maintain all your software in your server and you are going to provide them access?
machine learning model is one of the.
Yeah, you are planning to provide them as a SaaS model.
Yes,
Service.
yes, yes.
You will be providing them a user credential. Using that user credential, they can access your portal to avail that service. That is the way. In that case, depending on the number of users and depending on the subscription, and you can restrict their access.
That model we are actually following. So there was one more model which
there are two types in software. One is a package.
Yes,
you can provide them as a desktop package. They can install the software on their system and they can use it.
Yeah.
Okay. And second one is web page. Web page, there are many types. Web page, one is a cloud-based SaaS model. They can only allow to access through their user credential, and depending on their user credential, they can access only the portion that has been provided to them to access.
Yes,
and you can restrict their number of user access and a number of facility access, and many things can be done. Role-based access rights and user-based access rights, and that can be done only through your system. In that case, they are not allowed to use. We can restrict the end user to use only the portion which has been assigned to them, and that way, there are variety of things are there, and you can restrict them to use your system for a number of hours and number of months, and depending on that, you can restrict them. There are many ways. And in that case, you no need to have any kind of license agreement with them, and that is implicit with the software what you are providing them. No, you will go with the licensing agreement in the user right, subscription.
EUL, end user license agreement.
Right. End user.
So
having the license agreement that is embedded in your system, depending on the subscription they are accessing and they are paying. Depending on the subscription level, they can use that.
Yes,
apart from that, they are not at all allowed to use.
That's it.
So license will become applicable to you only with respect to the end user, right? So all of us, when we install a new software, we hardly go through the license agreement, but we say I agree to the terms and conditions. So that agreement becomes crucial for you. You need to be careful with regards to that agreement and ensure that all relevant clauses are there in the end user license agreement.
There are two types for you. One is end user agreement for general. Another one is subscription license. Every type of subscriber will have their own rights and responsibilities. Depending on the amount what they pay. Subscription may be for monthly subscription or quarterly subscription, yearly subscription. Depending on the payment what they made, you can make a agreement different. What the facility we are going to provide to them, and accordingly you have to make them available. It should differ with respect to the type of user and type of subscription.
Okay, you are actually version 1 is version 1 and facility of features. You are trying to sell some technology. We get directly okay. One consultant firm, and we give them this is the whole features of this, capabilities of this. Would you like to buy fully? Is it possible? And they will not sell. After that, they will not start selling that. Is it possible?
In online version, copying and selling is not possible actually. In the only case is possible if the package as such is provided to them as an installable product. Only in the case of installable product, the product can be copied and can be installed in other systems and can be used. Even in that system, there are serial key access and those. Cracked version is possible only installable version. You know, if you are going to provide that as a SaaS model, there is no way of copying your product. You are going to provide them only the username and password.
Build this install agent model, and if we can give you this in their servers or in their then we have some restrictions, so they cannot.
You know, that is why, you know, how you are going to provide your product to the end user. Depending on that, the agreement has to be come again. If you are providing a product as such without copying, and you have to mention that in the agreement, you can say this should not be copied, and like that you have to sell it.
Yeah, advice for you what to do in terms of security.
Better actually, you know, always in nowadays the system, the market is nobody is ready to set up their own server, set up their own system, set up over their own network. If you are going to have your own network and everything cloud and all, you can go as a SaaS. That is easy for you as well as the end user. And only thing is the privacy and security. You have to assure the privacy and you have to assure the security for the end customer. And the customer is ready to set up all their infrastructure. He can go and install the entire setup in their campus, and he can provide as a standalone product only for them. If they are particular on the privacy and security. Okay, it depends. Okay.
Main product military and
There are lots of private entities nowadays in the defense sector.
But you have to tie up with defense, DRDO kind of the defense entities, and you can, you know, you cannot sell privately to private parties. Defense products, and you can tie up with those entities, and you can manufacture and sell it to.
Directly sell everything, should the government directly take over everything is your question. That is not the case. You can form a private company.
Yeah, Odisha, you may have had that. Odisha and Coimbatore, they have an incubation center. They are promoting purely on a defense related industry. There is incubation.
So, but the defense sector has opened up a lot nowadays.
They are promoting. Odisha level.
Your voice is feeble.
belongs to national security.
Okay.
How can idea? How can idea government?
You have an idea related to national security. And what is your question?
How to reach the concerned department?
How to reach the concerned department? The thing is nowadays all departments, through such incubators and through their ecosystem partners, right? They are conducting all sorts of events, ideathons, hackathons, and, pitching, everything is happening. So incubators play a very important role in the ecosystem. And through these incubators, these, government agencies will come to them and, they will conduct events. So you see where such, events are being conducted by the DRDO. Or, you can even through your incubator, you can approach, right, the Ministry of Defense or DRDO. And, maybe a visit can be arranged here. And, once they come in, you can try, pitching your idea to them and, see how it works. So basically access, will depend on access generally takes place through events only. So,
hello everyone. I take immense pleasure in rendering the vote of thanks on behalf of the management and the ACIC Kalasalingam Innovation Foundation team and all the others present here. I thank the honorable guests, Mr. Venkatesh and Ramesh Kannan, who have shared the insights about patent, trademark, and copyright. And I'm sure all the students present here and all the faculty members and the ACIC team have been benefited throughout. And especially, I hope the students who clarified their doubts have really got solid inputs by differentiating about the trademark, patent, and copyrights, respectively. I thank the management for giving us the opportunity to provide us with all these facilities and making us ensuring the best out of each and everything. I thank Dr. Subhatra ma'am, the CEO of ACIC Kalasalingam Innovation Foundation, for making this initiative a successful one. And overall, I thank each and every one of being a part of this event and making it a successful one. I also thank the students, the faculty members, and participating colleges of the Ideathon winners who won the prizes for making their presence and achieving the best out of this event. Thank you once again, and thank you for joining us.